This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on topics that matter to you, like artificial intelligence. Learn more at pli.edu/AIPod.
Welcome to AI and Data Law, part of the PLI Evercurrent podcast. I'm William Tanenbaum, host of the podcast and head of AI and data practice at Moses & Singer in New York. In this series, we bring you the latest perspectives on AI and data through timely talks with thought leaders working at the intersection of AI, data, and the law. In this episode, my guest is Greg Silberman of Kilpatrick, Townsend, and our topic is Generative AI and Privacy Law. So, hey, Greg, and it's great to have you on the podcast. Today, we're going to talk about the new privacy laws and how they affect generative AI and enterprise data. And I'm very pleased to have as our guest Greg Silberman. Greg and I go way back. Greg and I were partners at K-Scholer. We worked together on a NASA matter. And then Greg moved out west and has done some very interesting things. He's now a lawyer at Kilpatrick, Townsend. But Greg, I know that you were at Lawrence Berkeley, which is not the normal career path for a lot of lawyers. So let's hear a little bit about how you went from genius scientist to genius lawyer.
Yeah, genius would be a stretch, but I went from electrical engineer to, while at Lawrence Berkeley Labs, realized that I was just super interested about how technology affected society and business. And so thought that the best way to get more involved with that would be moving towards, getting a law degree and approaching it from that angle. Went to UC Hastings, started my career as a patent attorney at Lawrence Berkeley Laboratory, briefly at Lawrence Livermore, and then decided that I wanted to leave the lab environment, took a job with a small IP boutique up in Seattle. And from there, I originally moved and joined you at Rogers & Wells in New York, just before it was assimilated by the English and it became Clifford Chance. And then we moved to K-Scholer together. And then I came back out to New York, worked for another big law firm, and then decided that I wanted to make the jump to in-house. And one of my clients we had raised money for them, and they hired me as their first chief privacy officer and to supervise their AI-powered IP portfolio. It was a company called Silence. That was the first of the next-gen antivirus companies that was using machine learning to basically identify malware, not by a signature, but by doing a feature extraction of what are the components of the underlying software. And then from there, we didn't take the company public, but we sold it to BlackBerry. And so I went along and served in a similar role at BlackBerry and was planning on returning to private practice, but found myself in the middle of a pandemic and was approached by Zoom Video Communications, who, I don't know, maybe you've heard of it. They had a small company no one knew about, and then there was a pandemic, and then everybody knew about it. And so when given the opportunity to build a privacy practice, a privacy team at Zoom and help respond to the Federal Trade Commission and the DOJ and numerous other privacy challenges at the company, it just seemed too good to be true. So did that. But I've always really enjoyed private practice. So when the opportunity presented itself to, return to private practice, I decided that I looked at a couple of firms and decided a really good fit for me was Kilpatrick, just because of its history of IP and then its very broad privacy, technology, and cybersecurity practice. So I'm here now, and really most of my practice is generally focused on either representation of cybersecurity firms or helping large enterprise firms with privacy, cybersecurity, and particularly AI. And just the fact, which is the topic of today, but just the overwhelming breadth of change that's coming in the face of, what some are calling an artificial, yet another artificial intelligence wave, revolution, renaissance, if you will. But I think we can say without a doubt that 2023 was the year that AI, from a legal standpoint, from a regulatory framework standpoint, started to get real, and it drew an inordinate amount of attention.
Well, I actually did a Gen AI introduction for you, but I decided it didn't do you justice. So
we can go there, but I think that I think that at this point in 2024, enough people have heard the basic explanation, and many people have sat and either played with ChatGPT or Bing or Copilot. And so folks are starting to become familiar with it. And many, even realize that like LLMs are a type of AI, and that GPT is, generative pre-trained transformer. And sometimes, a lot of the words that like last year nobody knew. We're starting to have a population of practitioners and folks who know what they mean now. But now the question becomes, okay, that's great, but how do I address that from a governance standpoint? How are those impacted by current laws that we have on the books already? And what do I have to do to be prepared for the future and this seeming wave of AI regulation that we're going to be facing in the coming years?
Yeah, so let's start right there. I mean, I definitely want to get your views on privacy. And, I've always thought that you could have security without privacy, but you couldn't have privacy without security. And
that statement is 100% true. I though at times do wonder, without privacy, who cares how secure it is? Because
right.
then if it's being abused, great. Only a limited number of people are abusing your human rights. But I think that statement is 100% true. You also need both privacy and security in order to provide trust. And now with AI, I think we're also looking at this and going, well, what about transparency? And what about addressing other concerns around safety, such as bias? Because we have a lot of laws that are around, hey, no bias in the workplace, no bias in lending, no bias in healthcare, that are really originally were directed towards, humans. And then maybe some tools that were doing calculations that may have been based upon, well, socioeconomic depressed areas tend to have, poor results. So we don't want to insure individuals in those areas, or gee, these poor neighborhoods, things aren't as maintained as well, or there's more risk of crime, so insurance rates will be higher. But now we're having to ensure that, like, for example, tools that we build don't, basically based upon the data that was used to train those tools, carry over some of these biases and have these negative impacts on human beings because of the way the technology was built, even though the coders are best of intentions. If they did not then, come up with a mechanism by which they could then examine the technology and examine, both the input data, but also the results, becomes problematic. And we're seeing this being addressed in general regulations like the EU AI Act, sectoral regulations such as New York Public Law 144 with relation to automated decision-making and hiring practices. And then also we're seeing specific industry verticals approach this. The National Association of Insurance Commissioners has issued guidelines directing insurance companies on their usage and development of AI, and the problems they need to consider, and that they're to consider the possible negative impacts upon the insured. And then that then propagates out to them having to ensure that their, terrible usage of the word insure twice in the row there, but having to verify that their service providers and the tools that they are bringing in to do this analysis aren't biased as well. And
yeah, I think that's really interesting that, if you're talking about a company with enterprise data, or even a large body of PI, personally identifiable information, or personal data, depending on the reg you're talking about, at some level, it seems to me, you're relying on the privacy policies of the third-party vendor you've hired.
100%.
And I'd like to get your comments on that, since I think you've probably been on both sides of this.
Yeah, I have. So you definitely are. When you are having a software as a service, or you are an enterprise business that depends upon lots of service providers, whether they're SaaS, professional services, even a few still software tools that you install and it does the calculation, and you download the updates periodically. You are dependent upon, one, what are their data handling practices? What data do they have? What data do they receive back? We're all going to see coming up, and there's a lot more concern around this, both in the mobile space as well as with these large platforms where you have just a wide variety of service providers and SDKs that are used to build software that then are exporting data back out to third parties that users have no idea what's taking place.
So to kind of either operationalize this or do a due diligence perspective on it, I want to tie this back to the privacy laws. So actually, before we go to the vendors, let's just start with the regulatory schemes that we have. Now, as we're recording this, we're pretty close to the release date of the European Union AI.
Yeah,
let me get your overview of this to kind of explain to people why it's not sectoral and what its key features are.
Right. So if we're taking a look at the EU AI Act, it is very similar to GDPR. It has a much broader range. It isn't just applied, this is for healthcare data, or this is for use in law enforcement, or this is for use in these. Now it does it based upon risk. So there are certain areas of usage of AI where risk is high. And where risk is high and it is processing data about an individual and it's going to make an automated decision, there is overlap with GDPR regarding automated decision making, but there is a much greater level of sensitivity. There are some that just flat out prohibition. Use of biometric facial recognition in public spaces. There are carve-outs for there are some carve-outs there for national security purposes, but generally the use of biometrics for those type of purposes in public powered by AI are going to be prohibited.
So what happens with the same time that these European companies or countries are taking your face scans when you're going through customs?
Yeah, I think a lot of that is going to tie back to, is that for a regulated national security purpose? And I think there will be this concept of that is permissive because it's providing security.
Interesting. So, Greg, let's talk about the EU AI regulation. Its current status, how it's risk focused, and then kind of transition into the executive order. But let's start with the AI.
Sure, that sounds
initiative
great.
In Europe.
So December 9th, 2023, there was the political agreement on the EU AI Act. A lot of the implementing regulations are still being ironed out, and how each country is going to really enforce it is still yet to be seen. But from a basic standpoint, AI Act is taking a very broad definition of what is AI. It's aligned closely to the updated OECD definition. It's extraterritorial. So just like GDPR, it is applying to any company that is collecting, processing, or using AI as applied to EU citizens.
So let's just stop there for 1 second, because I want to ask you if you can try and do this in a reasonable amount of time after the EU made it difficult. But how do they define AI?
It is, it is they have sort of definitions around general purpose AI. They have definitions around, various forms. But if we take a look at here, let's just go look at the OECD AI definition, because that actually has, a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. So basically, use a computer to do a thing.
Does that going to capture generative AI then, as opposed to predictive AI?
It 100% does, and that was actually part of the delay in having that almost blew up the AI Act because of discussions around generative AI, as well as discussions around carve-outs related to national security.
Got it.
So,
okay.
There are exceptions to the EU AI Act, including national security, military and defense, R&D, and open source, except the open source is only a partial exclusion because of the perceived risk of powerful foundational models being able to proliferate. There are a series of, compliant, and this act is going to be taking effect and grace periods phasing in over the next 6 to 24 months. It's very much risk-based, and so it starts with like there's prohibited AI uses, high-risk AI uses, limited risk, and minimal risk. And there are outright prohibitions, but then there's scaled requirements based upon how risky it is. There are very extensive requirements that are put out not just to the providers, but also the users of high risk AI. And then also, there are specific transparency and disclosure requirements associated with generative AI.
So, how do those work, at least under its current formulation?
Yeah. So, right now, a lot of it is going to be so, how does which work? The different types, the prohibition or the requirements, or the transparency and disclosure requirements?
The transparency and disclosure
Around
requirements.
transparency and disclosure requirements, it's going to be just as it sounds. You are going to have to identify and provide information about where the data came from. Individuals have to be informed when they're interacting with an AI, a chatbot. So if you're talking to customer service and you're going back and forth, you don't have to conduct your own Turing test. They have to tell you this is additionally content is going to have to be labeled as AI, and the providers of these systems are going to have to make it detectable, because one of the big concerns that we're seeing is going to be the massive proliferation in 2024 of technology available very broadly to generate synthetic media. And and that could be pictures, audio, video, and that's going to allow for very sophisticated deep fakes and very sophisticated, manipulative photographs, videos, audio recordings that are going to power, what many are concerned are going to power a wave of disinformation and propaganda, as well as power a new rash of criminal activity, from fraud to sophisticated phishing, that I think we are, just looking at right now and thinking, it's a little bit movie of the week, but it is, we've already seen examples of, business compromise attacks where software was used to impersonate the voice of someone, and a bank manager then transfers money. Or we're seeing frauds where, a parent or grandparent receives a call, and it's like, oh God, she's in danger, she needs the money and I can't quite hear her, but she sounds upset and I have to wire her money because they've faked the voice so well. And I think we're going to see this, just on the continuous rise. And the fact that, that is just one area of potential abuse.
Let's just jump ahead 10 years and assume that, generative AI is going to be used in a lot of stuff that companies are using to communicate with their customers or announce their products, or basically use it as a tool to generate most kinds of public-facing announcements.
Yeah.
At what point then does disclosing that mean anything?
Well, I think you're still going to have, it'll be a standard that, just like we disclose that this magazine article is a paid promotion. When you take a look at the New York Times Magazine and, there's a bunch of those sponsored, advertisement articles. It's going to be similar to that. Now, will people care when 90% of the content they're reading online is derived by AI? Will there be a backlash against it? And people say, nope, I want to read books by humans. I think you're going to, and then there's going to be a question of, well, what if AI is just used? I mean, there's a lot of unanswered questions. It's great to say you have to disclose. But what if AI is just used? I use AI to possibly, do an outline, but then I write it. Or I use an AI to do a first draft and then I rip it apart and mark it up. I think what we're going to see in the near future is a lot of usage. There's going to be people who are going to do dumb things like send out emails completely written by AI and send out announcements written by AI or news that are going to cause, problems. And I think that might be a case of not AI is bad or should be banned or regulated, but wrong use of the tool. And so being thoughtful about how it's used, I think, is going to be important. But I think that's not just in the EU. I mean, we're seeing significant calls for that here in the United States.
Let's focus
around identifiability. But I think one last thing to sort of think about before we move on, because this is, you're talking about for enterprises. As I said, in the EU, and that's an important market, we're going to have, prohibited AI usages. social credit scoring, as we see in China, is going to be prohibited in the European Union. Using emotion recognition, so being able to tell Bill looks happy, Bill looks bored, that, being deployed in work and education settings, prohibitive. AI used to exploit vulnerabilities, behavioral manipulation are all going to be issues. And then as we were discussing earlier, biometric categorization systems using sensitive characteristics, which could be anything, from race to, trying to guess whether or not you are in a protected class of one sort or another. And then there are prohibited uses apart from limited pre-authorized situations where law enforcement is being prohibited from using real-time biometric identification in public. So it's okay to go search for someone, but you can't continuously monitor where Bill is in London 24/7 without cause.
That's good to know.
And then that, I think, is less interesting for U.S. companies because there is a flat prohibition. So unless you're selling to an agent that can use it, I think the more interesting one is going to be the high risk, and that's going to be medical devices, vehicles, recruitment and HR, anything for critical infrastructure, emotion recognition systems not being used in work and education, law enforcement systems, for border control, migration, and asylum, and then anything related to administrative justice, where a decision is being made about you that might have a negative impact on your freedom. And then, that's going to be governed by, doing fundamental right impact assessments, registration of the technology with a public EU database, going to need to have a risk management framework established, data governance, including bias mitigation established, as well as transparency, human oversight. So, the human in the loop, which is a control, an operational control that always gives me concern. That's like, great, you put a human in the loop. What if they're biased too? Or you put a human in the loop, it's very easy to become dependent upon this AI system that's right 99.9% of the time. And then, just the accuracy, robustness, and security of the system, and the obligations there are going to be for continuous testing and monitoring.
So if you're a U.S. company, you've already been through the GDPR exercise.
Yep.
How is it going to be similar for the AI exercise?
I think it's a broader range of considerations as opposed to, whereas GDPR, you have this, has like this general lawful basis. This has specific bases. It's like, hey, this is, a high risk usage, so you have to do these things. This is a minimal risk usage, such as, using AI to give you a nice Gaussian blur in the background of your video conference. Is that one that's going, where it's just, identifying, okay, there's a human being in the middle, will blur the background. Doesn't know if I'm a man, a woman, hell, it doesn't even know if I'm human. I could be a dog. I've done this.
Is there an equivalent to DPAs?
I would say that the fundamental rights impact assessment of conformity is going to be similar to doing like a privacy impact assessment or a data protection impact assessment. I think that the DPA doesn't exist per se. At least there's no standard contractual form being, promulgated just yet. But I think, there's going to be what we're going to emerge is a series of assessments and documentation that are going to become, best practices. And I think that is what we're going to see. And just the disclosure obligation. So, in some way, the transparency that you're going to be obligated to provide to a user of the system or the purchaser of a technology, I think is going to end up being part of, exhibit. It just doesn't have a name like DPA just yet.
Let's pivot to the executive order, which is another interesting and recent development.
Yeah, definitely.
It seems to me at some level, and I'm going to let you explain this, but my conclusions are, it directs the agencies to do certain things within the sphere of, their competence and jurisdiction. And I think that's going to lead to them hiring, third-party private sector consultants to help them get there. And I think at the end of the day, they're going to establish some practices that'll turn into effectively best practices because now a lot of agencies have spent a lot of time perfecting their approach. And then after that, it might be a de facto safe harbor that if you do what's in that sphere, it's going to be hard to criticize you for not doing enough.
Yeah.
But
And I think that is, a generally like a reasonable thought. So the the executive order on AI that was issued October 23, directs just about every agency in the federal government to make guidelines, rules, best practices, in a variety of areas directed towards, effective, safe, trustworthy AI systems. Probably some of the more significant ones are the directions given to NIST that earlier this year published its risk management framework in January 2023, talking about,
let's
hey,
just tell everybody what NIST is.
okay, so NIST is the National Institute for Standards and Technology, and they basically create the standards by which various technologies can be measured and guidelines for the effective. They are not generally applicable to enterprises, but these are directed to, tend to be directions that are adopted by government agencies, and then also are in many times viewed as a set of best practices, not necessarily the absolute best, and sometimes there's controversies, but it's well respected, and it's usually a thoughtful, fundamental basis for whether it is a standard on secure how to secure a network environment, or how to they're doing right now on differential privacy. They have a recent request for information out to the public about they're publishing guidelines on doing differential privacy. And
So we need two sentences on differential privacy before I let you move on.
okay, sure. So,
and I know this is definitely at least a 3-sentence explanation.
yeah, it probably is. But differential privacy is a privacy enhancing technology. It's a mathematical technique in which, when you collect a bunch of personal information about an individual, that you don't necessarily want to have all of that information, in a single database, or someone might be hesitant about providing all of this information because securing it is difficult, and you'd hate to have like all of your medical records lost, or all of your, personal data lost if there was a breach. It's a way of ensuring privacy by adding a bit of noise to certain elements, and that noise can be in the form of, hey, if it's a binary question, yes, no, a certain percentage of them will be randomly flipped from yes to no, or no to yes. Others will slightly alter an age, alter an age randomly up or down 10%. Shift street addresses slightly, if that matters. Slip zip codes slightly, if it doesn't matter. And then in aggregate, that data can be examined, and you can go, okay, I can still extract valuable information from this in order to, conduct, for example, the US Census. It's an example of, an agency that uses differential privacy already. Now, there are some concerns that differential privacy, maybe loses some of the important detail, and can, depending upon the amount of noise injected, render that data useless or undermine it. There's also concerns that, powerful AI technologies can be used to re-identify individuals because, gee, in, some of these answers you can flip randomly, but if you know what the percentage is that's being flipped, you can take a guess, and you may be able to re-identify a person based upon it. It has limitations, but it is a powerful technology, and it's also one that's more easily implemented than, say, something like homomorphic encryption, which allows you to manipulate and search and encrypted data, but has a very high computational cost, is very difficult to manage and maintain, and so really is only a solution for a limited number of use cases for a limited number of actors at this time. That's another technology that's getting better over time.
So I want to step back now. What did the executive order tell NIST to do?
So NIST was directed to develop best practices, guidelines, policies, controls for development and use of AI that is safe, secure, trustworthy, and fair. And so they've been told to go out and come out with the evaluation criteria to be applied to AI, including general AI systems, as well as narrow AI systems, as well as generative AI. The executive order also has a significant focus on the size and power of the models, going so far as to designate a specific size of model or a size of cluster of machines in terms of like floating point operations that, if created or used, must be registered with the government. Currently in the US, there's only a few companies that are large enough to actually create these systems, and none of them have hit the limit of the general requirement just yet, but when it's foreseeable that they will. And then a lot of the directions are, how are you going to test it? And so what are the testing methodologies to be applied to AI? How do you determine if it's fair? How do you determine if it's secure? What does red teaming, that is adversarial testing an AI system, look like? And there are very specific directions towards NIST to developing this. Now, I don't know when people are going to hear this, but it's actually, I think, really timely to raise the fact that NIST isn't going out and hiring a bunch of people. What they're doing in the private sector, what they're doing is they have just had a call for information, an RFI. So if you visit the website, you can participate. Anybody can participate and submit information on a set of various topics related to this and contribute to the thinking. And this is something that's very important to do because they do keep track of who has participated in the RFI. You may be called back to give additional input. And if you complain at some point in the future, they're going to be a little less inclined potentially to listen to you if you weren't bothering to participate on the front end. So it is an opportunity for companies to help contribute to how will these guidelines be developed, and to basically share their knowledge with NIST in its development of these policies, procedures, guidelines that are going to be adopted, and in many ways in the United States become the de facto as to how what constitutes a safe system.
And how does this relate to the different categories of risk under AI in Europe?
Yeah. So a lot of it has to do with, what is the potential impact? And the U.S. seems to be focused on some very, specifically technologies. The executive order focuses very specifically on, technologies related to deepfakes or to synthetic data of CSAM, child sexual abuse material, or fake intimate images. That's one area of concern in the US that's like, nope, we really want to make sure we lock down on that and we don't lose the ability to track and trace and stomp that out. Another area is the use of AI in the development of biological, nuclear, or chemical weapons. Because as we've already seen, generative AI is a very powerful tool. It's being used now in drug discovery. It's being used now to do model protein foldings. However, we've also had a couple instances where, just as an experiment, researchers set the task of develop some harmful or toxic materials, and it basically overnight a system. This isn't Chat GPT, but a purpose-built drug discovery system, discovered thousands of highly toxic compounds. Now, give me 1,000 highly toxic compounds I can, manufacture from chemicals on this list because they're not controlled. Okay, that becomes scary.
And we used to worry about viruses.
Well, I think we're at an age now where, looking at this, you can also imagine this in combination with sort of the coming future of synthetic biology, people being able to designer viruses in a similar manner, where you use AI to map it and then are able to use synthetic biology printers to generate that viral strand.
So before we move on from the executive order, any other kind of overarching comments that a company would need to know as they're re-engineering their operations in anticipation of this?
I think a lot of it is going to have to do with being flexible, because right now, a lot of these, we're not even 90 days in to the executive order.
Right.
they're out collecting information, they're drafting, the actual specific regulations aren't there. I'm going to say, for companies, probably the most important thing is know where you're using AI, catalog it. This sounds simple, but cataloging all the instances where you're using AI throughout your organization, simple thing, maybe not the most simple thing to do, but it's a discrete task you can undertake that will help with your compliance obligations later on. Identify who is using it and for what purposes. Also identify, those AI systems. Well, gee, are those public AI systems? Is this like, a publicly available chat GPT? Am I accessing it through some third-party API? Is it a private instance that I have built for myself and I'm running on my own iron? Or is it in an Azure cloud? Is it something that is facing and only used internally by my employees? Or is it something that I put out towards the public? And then examining, and going through all the elements of where you use it, what's the source of it, examining, gee, are there any third-party supports for that I should be concerned about? Maybe checking the agreements with your AI service providers to determine, hey, are they able to, what data, what rights am I giving up with regards to my inputs? What liabilities do I have? Do I have any indemnification as to the outputs of that system? Are they going to protect me if it infringes on someone's copyright or the code that I've used generative AI to create? What if it infringes upon someone's open source license? And all of a sudden I've reproduced, some GPL code and I get a claim against me for that.
Yeah, that will be interesting. Let's talk about other areas of regulation. Should we address the FTC?
Oh, yeah. Let's address the FTC because the commission has definitely demonstrated that it is going to regulate AI. From just in 2023, we saw 2 more instances of algorithmic disgorgement handed down as, an enforcement mechanism. And
so explain how that sanction works.
Yeah. So algorithmic disgorgement is typically a penalty that's handed out when the base data that you used was obtained without a proper consent, whether, deceptively or potentially even just illegally, because you scraped it from somewhere you shouldn't have, or found it, or, you didn't tell people you were going to use the data from this. And there have been instances that they've pointed to and said, you're collecting data from children without proper parental consent. You were taking data from a social network without proper consent and then allowing others to use it and build these systems. And then, we've seen, others that are just predicated on you didn't have the right to the data. And it can either be get rid of the data. Okay. But then what if you have an AI model built upon that data? Well, you got rid of the data, but you still have the model. So get rid of the model.
That's the
as well.
discouragement.
And that's the problem. Now, theoretically, you could have companies approaching this from the standpoint of, well, definitely be very careful about what your source data is, especially if it involves personal or sensitive data, to ensure that you have the right to use it. Otherwise, the FTC is, more likely to be coming down on you for that than they would if, if you have clear consents. It's not the issue. Make sure that you safeguard that data. Even if you have consents, make sure that, and you collected that data in an appropriate fashion. Make sure you're safeguarding it and that you're being transparent about how you're using it. Because I think those are also going to be, significant bases for this punishment. The other is going to be, and there's research being done on this, and it's not easy to do. And right now it's a little bit over the horizon, would be rebuilding the same model after you redact that data or redact the infringing data or replacing it with synthetic data. And I think that is something that we're going to see, emerging as a possibility, but right now is prohibitively expensive, very difficult, often beyond the reach of, a company to do. And so they typically just have to, purge the model, start from scratch. So in addition to algorithmic disgorgement, the FTC has demonstrated a willingness to, take up the mantle of enforcing consumer protection around the use of artificial intelligence and biometrics. Most recently, with regards to Rite Aid pharmacies. Rite Aid had deployed biometric facial recognition to identify shoplifters. And the FTC, unfortunately, the Rite Aid had the tech, and then he would identify people. Rite Aid was then calling the police, having employees stop them, accusing people of shoplifting, having people's bags searched. And unfortunately, the system that they were using was biased towards persons of color and women. And so they found that the FTC made the determination and recently came to a settlement with Rite Aid that one, you were reckless in your use of the technology, and two, you can't use it again for 5 years. So no use of biometric tech, AI facial recognition within Rite Aid stores for the next 5 years, basically saying you're not allowed to play with AI because you can't be trusted. It's basically like after your kid gets in a car accident, taking the car away until they're older because we can't trust you to do this.
What would be the result under the EU regime on that one?
Oh, it'd be prohibited. Flat out. Under the EU AI Act, that use of biometric technology would be banned by a private store. I mean, as we said, there may be some instances with law enforcement or, hey, we have a list of people on a no-fly list and their biometrics are registered and they're going through an airport. That might be permissive under the EU AI Act, and I suspect it would be. But I look at this and I go, there's absolutely no way that they would allow stores to deploy their own detection routine that's using, biometrics to identify potential shoplifters.
That will be interesting. What other key regulatory developments do you see in the U.S. At either the national or the state level? And we'll come back to New York in a second.
Yeah. So what I'm seeing is you're going to see, this series of, regulations come out at the federal level in a bunch of different sectors because it's, hey, how are you going to, patent office, what are you going to do? Copyright office, what are you going to do? NIST, how should we make it safe? One after the another after the next. You then have state privacy laws like California that has actually just at the end of the year promulgated the draft in December of its automated decision-making rules, which are basically part of California's privacy regulations. So it's under the CPPA, the California Privacy Protection Agency, as well as I presume, as well as potentially enforceable by the state AG that deal with, and they're just in draft now, but deal with automated decision making, and a lot of that is focused on fairness of systems, making sure they're not biased, safeguard the data, because it's really just an extension of CPPA.
And how come more states have not followed Illinois on the biometric?
Yeah, there are numerous states have floated laws, including many surrounding it, and it hasn't passed. I'm not sure why it hasn't been pushed as much. Maybe that the plaintiff's bar isn't lobbying hard enough in those states because, the big issue with the Illinois law is that I don't want to be critical of the drafters of the regulation, but the terms are very broadly defined. It is somewhat vague in areas as to what constitutes biometric data, biometric information, a face scan, and then the private right of action. And it's a private right of action that has, BIPA has very significant, BIPA being the Illinois Biometric Information Protection Act, has very significant penalties. And so that's why you've seen a lot of energy around that. We're also going to see some energy, I think, this year around Washington State and My Health, My Data. This isn't, an AI act, but it is it is a comprehensive state health data regulation. It also has it's more limited than BIPA's, but it also has a private right of action.
It's going to be interesting. I suppose just looking at the head, we're gonna have a federal supremacy argument then.
Well, maybe, because if you think about it, this 2023, we saw 8 states pass comprehensive privacy regulations. And we're going to see by the end of 2026, there's currently 5 that have comprehensive privacy regulations. 8 more have passed. And then I think, well, actually, I guess Utah, so 6 has kicked off. So we're going to see these phase in over the next couple of years. And so by 2026, over a third of the US population will already be covered by a state comprehensive privacy law. And these are, you have California with, I would say is the pioneer, and actually has, dual enforcement authorities in the Privacy Protection Agency and the state AG. And it covers everything from general comprehensive regulation to automated decision making to, they're creating a, data broker registry that is going to come online in the not too distant future, as well as we're seeing the California Age Appropriate Design Codes. We have a very robust regime here in California. Then we have, say, Virginia, which has created a strong baseline set of privacy protections that's been followed by some states. And then we also have a group of other states that are basically similar to Virginia, but with some exclusions or some things left out because they're trying to remain more business friendly, or they just don't have the ability to enforce that broadly, so they're not going to write laws they're never going to enforce.
Let's switch now to security, and I'd like to talk about the offensive and defensive use of generative AI in malware and anti-malware, and just keeping the security of enterprise data. And let's just focus on non-personal identification, just business assets that are important to the company. And let's say they embody trade secrets, or they embody future business plans or customer lists, all the kinds of things that companies are concerned about. And so, it strikes me that generative AI will allow programmers who aren't so good to do damage that they couldn't do a year ago.
Oh, definitely. When I was younger, there was this, you hear the phrase script kiddies, and those would be, potentially teenagers, people who, didn't have any real coding skills, but could go onto a bulletin board, or today it would be more the dark web, and download a tool. And that tool would allow them to, hack passwords or dial a bunch of phone numbers looking for a modem, then try a bunch of try a bunch of passwords, or try and scan a website and looking for open ports or some well-known vulnerabilities. And so what you're going to see is AI turn to those tasks. As we meant, as been discussed, generative AI can write software. Generative coding is here. It's very powerful. Is it perfect? No, but it's getting better every single day. And the ability to write, powerful software tools, with, low coding skills is going to make it available to a broader audience. And so I think that's one area, is that malware can be created. Variations of malware can be created. And then we have, this broad range of tools to detect and block, but it's always an arms race. And so you imagine if you have malware that is being generated by AI, and and every single piece that's sent out is varied, it may determine, one, for simple systems that are just looking at, a hash of the code. Yeah, you could simply do that by just spinning or packing the code, and the AI would be overkill for that. But for systems that are looking at the features, it may be able to discover patterns of features that a sophisticated, currently today, sophisticated AI antivirus system, it might be able to bypass. Tests like, CAPTCHAs,
Yes.
or determining, are you a human? Where it's looking for human interaction. AIs are getting to the point where, they'll be able to bypass those. These systems will be able to, pass some of these tests. Which of these things is a bicycle? It's like, okay, a lot of image recognition is really good. So I think, that is going to be an area. So the ability to generate malware, you can get a little bit more sci-fi if you imagine, malware that's crawling, a worm that crawls the internet, finds a system, examines it, and keeps generating new malware while it's there, and then keeps attacking different systems and just utilizes those resources that it finds in situ to grow and develop itself. And then it moves on and looks for new systems to attack.
I just have some theory that the people doing this will not comply with the transparency laws and the.
No, I think that's a fair statement. Now, the nice thing is we also have the good guys and the cybersecurity industry that is going to be focused on, detecting and blocking this as well.
So I'm really interested in that. How is that going to work? How are they going to win the arms race?
Well, we showed that at Silence. I mean, years ago, just using feature analysis was part of it, and we're able to, using a machine learning model, that was 18 months old, stop in some instances newer versions of malware. Highly successful. Now, eventually the bad guys learn and move on, and so the question is going to be: is there going to be enough sharing between the defenders that they are going to be able to, sharing of information and models and indications of compromise amongst the defenders, that they're going to be able to defend against that? I think, there's going to be a lot of concentration from industry. There's going to be a lot of research is going to be done on this. Now, some will be published, and that'll give, some of the attackers an idea about how things work and how to attack it. But I think that, this is an era when we're going to see a lot of back and forth. There will be sometime next year some big hack that's a result of, generative AI malware. There will also be a bunch of, attacks that are based upon someone sending a clever email or making a phone call and social engineering someone to do something. So I think it's another tool that the bad guys will have. It's another tool of, state actors that they will, that will be used. But I think that it has a lot of focus now, and it's a lot of concentration is taking place both within enterprise and at government levels to ensure that we're developing the technology. I guarantee you, when you go to RSA this year, you're going to see a bunch of vendors showing off technologies to identify and block AI generated malware.
That'd be good. I think we're coming to the end, Greg. Is there anything else you'd like to suggest we cover?
No, I mean, I think, we've talked about, the sort of coming wave of regulation, which I think is interesting because we're going to be seeing it both in the United States, at the states, at, your New York City level, and as well as industry groups promulgating guidelines. We're going to see, various international, we talk about the EU AI Act, but, China has put out interim guidelines. Brazil has put out interim guidelines, to regulate this. And, I think we're seeing, just a much broader range of interest in this than we did amongst privacy, when privacy started to be a concern and started to be regulated. That was much slower out of the gate than, say, we are finding AI to be. However, I think that means we're going to just see a much bigger quilt of patches of regulation globally.
All right, so this is a little bit out of the sky, so to speak. Going back to your Lawrence Livermore days, any of these regulations extend to low Earth orbit satellites?
Low Earth orbit satellites. I mean,
A, are they high enough to be out of the jurisdiction? And B, they're moving. They're in orbit.
I think it's going to be the companies that are using them. And I think that if it's collecting data about an individual on the Earth, the extraterritoriality is going to extend into orbit, as well as the fact that data isn't just staying in space, it's being returned, and decisions and actions are probably being taken back on Earth. So,
all right, so I guess that moves the decision making up to a higher orbit then.
Anyway, Bill, thank you so much. This has been an absolute pleasure. As usual, it's always great to talk to you, and it's always interesting.
Well, thanks very much, Greg. There were tremendous insights, and we look forward to doing this one again, especially when we come back to the transparency issues and all the problems with securing data against the emerging malware threats.
Yeah, and I think, emerging malware, but it's also going to just be shinier, better versions of, some of the traditional fraud and scam that we've seen. I think that, the ability to generate really persuasive writing based upon scraping someone's social media feed or generating fake photographs from the party you were both at a week before, and then sending that off to somebody to convince them that you're, someone you're not. I think it's scary, it's fascinating, but I think at the end of the day, it's just a reality we have to be prepared for, and so we'll be addressing it as it comes at us.
Well, thanks again. This was terrific, and I appreciate all the insights.
All right, take care, man.
Thanks for listening to AI and Data Law, part of the PLI Evercurrent podcast. Please note that the views and opinions expressed in this podcast represent those of the host and individuals being interviewed, and not necessarily those of PLI. For more AI-related content from the Practicing Law Institute, visit pli.edu/AIPod.